You ready?
Yes.
State's ready? Defense is ready? Oh, wait, we have to wait for Mr. Sievers. Okay, for the record, both assistant state attorneys are present, both defense counsel and Mr. Sievers. State's ready to proceed?
Yes, Your Honor.
Defense is ready?
Yes, Your Honor.
Okay, as to the two instructions on principles. First, do you agree to the language that's been put in the instruction regarding principles does not apply to the conspiracy charge?
I agree with that language.
Okay. I'm going to note your objection for the record as to giving both, but I think both could be argued and the state's entitled to have both.
Okay. And then just for the record, Your Honor, notwithstanding my objections.
Yes, sir.
Okay.
And at this time, you renew all objections.
I renew all evidentiary objections. I renew all objections to business records and my prior judgment of acquittal and objections to the jury instructions.
You rest at this time?
I do.
You can do it in front of the jury, but
Yes, we rest.
okay, and you can make any additional arguments to your JOA motion at this time since you've rested.
And Your Honor, again, the standard now is whether a reasonable jury could convict Mr. Sievers. And at this point, again, the only direct evidence we have is from Mr. Curtis Wainwright, whose testimony is in exchange for a favorable deal, who has admittedly lied over the course of the investigation, whose testimony is in conflict with other evidence in this case, who is a 5-time convicted felon. And so, Your Honor, the jury, a reasonable jury, could not weigh Mr. Wright's testimony in a manner in which it would be believable enough that a reasonable jury could convict Mr. Sievers for first-degree murder or conspiracy. I again renew my objection as to the strict construction of the indictment. And again, the court recalls the indictment was pled in the conjunctive as opposed to the disjunctive. So Curtis Wainwright and Jimmy Ray Rogers and Mark Sievers must confederate with each other, with one another and each other, in order to form this conspiracy. And I think we were a little bit in the weeds as far as strict construction of the indictment versus some of the case law where this issue wasn't raised. And Your Honor, it is again my position, and I previously put the cases on the record, that the rule of lenity applies to an indictment. And when the rule of lenity applies to an indictment, if there is any ambiguity, that ambiguity must be resolved in favor of the defendant. Here, there is no ambiguity. And so by strictly reading the words of the indictment and then applying that to the evidence is clear. There was no contact regarding this conspiracy. The contact between Mr. Rogers and Mr. Sievers was de minimis. They met, they may have exchanged some pleasantries at the wedding, perhaps the night before. But Mr. Wright said, I did not talk to Mark about Jimmy, I did not talk to Jimmy about Mark. And so we do not have a full conspiracy as it's set forth in the indictment. Accordingly, Your Honor, if we read the indictment, and if we take the indictment at face value, the state did not present a prima facie case. And if they did not present a prima facie case, the court must grant a judgment of acquittal as to that issue. Thank you, Your Honor.
State.
The state adopts all arguments previously made to the court and notes that the issue is one of credibility, whether a jury can find the state's evidence credible. The state's evidence as presented does support every element of both charges, and so the state asked the court to deny defense motion.
I'm going to deny the motion for judgment of acquittal at this time, and all previous objections to that are noted for the record. Ready? Defense is ready?
Yes, Your Honor.
Bring them out.